Hey y'all, Rob here with ATX Legal, here with the second part of the Assault Family Violence Guide for Travis County. This video discusses bond conditions and emergency protective orders that go along with assault family violence cases. And the first condition I'm going to talk about is the stay away order, and this can be a condition of bond and it can also be part of a protective order. So there can be two ways in which a judge imposes the condition that you must stay away from a specific person. That can create some confusion because you can get the bond condition removed that you must stay away, but then the emergency protective order is still in place. So a person might think, okay, now I'm free to go visit with my significant other, but there is still that protective order. And if that protective order is in place, it is a criminal offense to even be in the same vicinity of that person, and you could be charged. And I'll talk in a moment about how that emergency protective order can be turned into a more permanent order later on in this video. But the second condition I'm going to talk about is the ankle monitor. This is the device you hear about. You maybe have seen it in movies. It's a device that fits around your ankle and it gives a continuous GPS signal so that your location can be tracked. Usually that's done in conjunction with a stay away order so that they can see if you're visiting the residence of the complaining witness. And if you are, that's going to be a violation. You're going to end up back in custody. Another condition a judge might include, and I've talked about this in the previous video, but it's just a cooling off period where you'll have to stay in custody for 2 or 3 days before you're released. Again, that just gives the complaining witness a chance to get their things, move to a safe house, do what they need to do to be safe, and also give a little bit of time for tensions to cool. Fourth, almost every bond is going to include the condition that you go seek counseling. There's something called Travis CES, Counseling and Education Services. You'll need to go get an assessment from them, and they'll usually assign you to do what's called BIP classes, Batters Intervention Program. And sometimes that can be a 12-week program. It can go 36 weeks or even 52 weeks. But based on that assessment, you'll need to go take care of those classes. And one thing to note is all these conditions are negotiable with the judge. So if we have support, let's say from the complaining witness, and they're saying, look, I want to drop charges, I want to see my significant other, I don't want these conditions on him, we can get that person in touch with the prosecutor who can then bring their side to the judge, and oftentimes we can get an agreed order to remove many or all of these conditions. So each case is different. If you have a complaining witness who is very much in favor of the conditions, it's going to be a little bit harder to get those removed. Or if you have someone with a long criminal history with a lot of violent charges, it's going to be more difficult to get those removed. But they are all negotiable, and it's something that your attorney can help you with. Sometimes after a period of time, like 60 days or 90 days, but these conditions are all negotiable. Now let's talk specifically about the emergency protective order, or the EPO. Now, the complaining witness does not need to request this on the date that the arrest happens. The police can go to the judge and get an emergency protective order. Now, after 90 days, that EPO expires, and that's it. You can go see your significant other. There's no protective order in place unless they have requested that it be turned into a more permanent protective order. And the way that happens, it's actually a civil matter, but it's handled in criminal court. In Travis County, they typically handle these in county court at law 4, although sometimes they are handled in the civil court. It's a weird one that can go in either civil or criminal court. But you will get served and there will be a hearing. If you do not show up to that hearing, it's very likely that the protective order will be put in place just automatically, and you won't get a chance to defend yourself. I don't recommend not showing up. You need to show up to assert your rights. If for no other reason, you can question the complaining witness. They have to give testimony. They have to give evidence on the record that an assault happened and that it's likely to happen again. So even if they make the argument that the assault happened, if they can't show that it's going to happen in the future, then they're not going to get that protective order. Another big reason to contest the protective order is that you do get to question them under oath. So if there's any inconsistencies in the statement from the complaining witness, you can really hammer those, and those are going to be on a transcript that you can order from the court, and you can use that transcript in your criminal case. And for that reason, sometimes the complaining witness will just drop the protective order request entirely because they don't want to go under oath. They don't want to have their story questioned. So by simply pushing back and challenging the protective order, you can sometimes stop them from even requesting one. Now, you're not entitled to an attorney at a protective order hearing, but I strongly encourage you to go and hire an attorney if for no other reason than to strengthen your criminal case. If the EPO is granted, it can be for 2 years. That's a typical time frame, but it can also be a lifetime protective order. It can go that far. And whether it's a 2-year or a lifetime, that's going to be determined by the judge. Now, in Travis County, the prosecutors are there to help the complaining witness file this motion and walk them through the process. And they're going to be negotiating with us as well. And what they'll often do is they'll try and strong arm you into just agreeing to the protective order without putting forth any testimony. And what they'll try to do is say, you're going to have to pay the fees. The court costs are $200 or so that you would be charged with paying if you contest it. But they're like, oh, we'll waive this if you go ahead and agree to it. But typically the judge is going to waive those court costs anyway. So it's not a real threat. It's just a tactic they use to try and get you to agree to that protective order without having the complaining witness take the stand and actually put forth evidence that there needs to be a protective order. Of course, none of this is legal advice. If you do have an upcoming protective order hearing, give us a call or visit us at atx.legal for a free consultation.